know, some YouTubers and content creators talk about how they don't like going through their comments. I, on the other hand, really enjoy it. Sometimes I get weird or not so nice comments. Sometimes I get really nice comments, really sweet stuff from you guys, which I absolutely love. But more importantly, I get a lot of really good questions from you guys, which is what keeps me coming back here, even though sometimes I really don't want to. But I know you guys have a lot of really good questions, and today I want to go through some of them. So let's go through your comments and tackle some of your very interesting trademark questions. First, hi, I'm attorney Aiden Durham with 180 Law Co. in Colorado. Even though I'm a lawyer, that does not mean I am your lawyer. The stuff I talk about in this video is not a substitute for actual legal advice. If you need help with any legal situation, including a trademark situation, you should consult with a lawyer. All right, now that that's out of the way, let's dive into your trademark questions. Can someone living outside the United States apply to the USPTO for a trademark? Absolutely. There's no requirement that you live or be in the United States to get a trademark registration with the USPTO. You just have to be using the trademark in commerce in the United States. So if you're in another country, but your business is in the US, you sell in the US, you advertise, whatever, if your business has activity in the US and you're using your trademark in the US, then yeah, you can do that. The little caveat though is if you don't have a location, if you're not domiciled in the United States, then you do need a lawyer to represent you through the process. People who are in the US, businesses that are in the US can do it on their own. I don't recommend it, but it's possible. If you're not in the US though, you do have to have a lawyer. How would I know if a name is trademark? I'm not sure if this question is asking, how do I know if a name is trademarked, like if there's already a registration for a name, or how do I know if a name is a trademark? So I'll just answer both versions. A name is a trademark if it's a trademark. There you go. A trademark is a word, phrase, design, symbol that is used in connection with the sale of a product or a service. So if you have a name, a business name, a product name, a service name, and you're using it in connection with the sale of your products or services, then voila, it is a trademark. How would you know if a name is trademarked or if a trademark registration exists for a name? You can do that by doing a search on the USPTO database. They have a search tool available. If you go to uspto.gov, you can find that. It's a little tricky, but you know, there is something available for you to search and see if a name is already registered. Be careful when you're doing this. We don't want to focus just on identical matches. If you've got a name in mind, it's important to search for anything that is even remotely similar to the name or the trademark that you're interested in registering. So variations in spelling, using different synonyms, you know, really anything that's even kind of similar could potentially be a problem. But so that's how you know. You search for it on the USPTO database. Is there a trademark lawyer that you recommend? Indeed, there is. It's me. Highly recommended. Me. You can find my contact info. You can get in touch with me. There's links down in the description if you want to schedule a consultation and start working together. The question is, do you dissect the logo and name into parts and submit them separately to the USPTO as two separate applications for each respective aspect, thus trademark? Or can you submit the logo and name together, like KFC and Colonel Sanders as one unified graphic, and thus submit one application for one blanket trademark covering both as a dual function mark under one submission? You can do both. You can do either. If your logo is designed, some kind of an icon or something, and your business name is included with the logo, you can register that design as one trademark. Or you can register the logo and your name separately as a standard character mark. Or let's say maybe your logo has kind of two separate elements to it, one icon and a separate icon. That again, is one trademark, and you can register that. But if you use the things separately, if you have, a version of your logo where it's just the icon rather than the icon and your business name, then that in itself, that version where it's just the icon, is also a separate trademark. The best thing to do is all of them. Register your name as a standard character mark, register the logo that includes the image and the name, and register the logo that is just the image. That way you protect all of the elements together and separate. When we're talking about a design mark that also includes a literal element, like maybe your business name, the trademark registration really is specific to that design. You get some protection over the literal element in it, but it doesn't protect it in the same way that a standard character mark would, because when you register the name as a standard character mark, it's protected regardless of how it looks. So again, you can do just the one version with your logo and the business name in it, but ideally you would do both or do them separately. How much does it usually cost to trademark a logo or word mark? Great video, by the way, thorough and easy to follow. Thank you. How much does it cost? If you're just doing it by yourself, then the only cost is going to be the USPTO filing fees. Those range from usually $250 to $350 per class of goods and services. So if we're registering under a bunch of classes, it's going to be that fee, times however many classes. At a minimum, it's going to be $250. Of course, if you're working with a lawyer, which I think you should, it's going to depend on how much that lawyer costs or how much they charge. Everyone's a little different. I'd say for a good experienced trademark lawyer, you should expect to pay at least a few $1,000s for that service, in addition to the USPTO filing fees. There are other filing fees that could come up throughout the process. If you filed on an intent to use basis, then there's going to be an additional fee due when you file a statement of use, or if you request an extension. If you get an office action, you can request an extension to respond to that, and there's a fee associated with that as well. So it's going to depend. At a minimum, $250. At a maximum, it's kind of up in the air. It just depends. Hi, I love your channel. Thank you. I have a question about website specimens. If I submit a specimen of my website URL, then later make minor changes to the web URL, like colors or text, will the trademark examiner reject my specimen because the provided links are no longer identical? I plan to update the colors and typeface on my site. No. If you use your website, like a screenshot of your website, as a specimen for the trademark, and then you later change something like the fonts or the colors, the typeface, that won't be cause to have the specimen be rejected. As long as the trademark is still there, that's really all that matters. Hello, I have a plan to file trademark application under 25, under International Class 25. Should I pick specific products to sell or have broader application to cover the whole class as clothing, footwear, headwear? Thanks. So to give a little bit of background about this, when we file the application, we have to identify the goods or services that we're going to use or that we are using the trademark with, and those things fall under international classes. Class 25 includes a lot of clothing and apparel items, and they can be broad descriptions like shirts, pants, footwear, headwear, or they can be very specific, like tank tops or athletic shirts or sandals, flip-flops, leggings, that kind of thing. Whether to be broad or specific, it depends. It depends, of course. We sometimes want to be more specific to avoid conflict with another trademark registration. If there's a trademark that's registered for a very specific type of clothing and that trademark is similar to ours, then we might want to be specific in the way that we don't overlap with those other types of clothing. We want to, make it clear that we're not selling the same types of clothing or the same types of apparel as this other trademark is. But if that's not the case, my kind of general stance on it is the broader, the better. If we're able to get away with a trademark registration for a broad class, like footwear or headwear, then that's going to be better. It's going to kind of give you broader, stronger reaching protection. And we can always narrow or delete goods or services after we submitted the application, but we can't do the opposite. We can't add or broaden our goods or services afterwards. So starting broad and then whittling down if necessary is better than kind of starting very specific or narrow in the beginning, usually. But again, it really depends. There's a lot of other factors that go into it, so it's best to talk to a lawyer. I've come up with my trademark name, but my actual logo design is from Canva. I'm trying to figure out whether or not I can use Canva designs with my trademark name without being sued. Only the name will be trademarked, not the images in the logo label. So the fact that it's from Canva doesn't really matter, especially if you're trying to register the trademark for the name. Then if you use the name in a logo that you created on Canva, that's not going to impact the registration of the name. The more important thing is, does this logo, whether it was created by Canva or any other tool or any other person, does it cause a likelihood of confusion? Is it confusingly similar to any other trademark, any other logo? Let's assume, you made your logo and it's totally unique. It probably wouldn't be on Canva, but let's assume there are no issues with it being confusingly similar to another logo. Then the fact that it was made on Canva wouldn't have an impact. Does this mean you can't trademark something until you put the good or service out to the public? Seems odd that you can't trademark something first, then release it. That is what that means. I've said this before and I'll say it till the day I die. A trademark isn't a trademark until it becomes a trademark. A trademark is a word, symbol, phrase, design that's used to identify the source of goods or services. So it's not a trademark until it's being used to identify goods or services. So correct, you can start the registration process. You can submit the application on an intent to use basis, which means you're not using it in connection with the sale of those products or services yet, but you have a bona fide intent to do so. But the USPTO won't register it until it's actually being used in commerce, which means you've put the goods or services out there to the public. When you haven't done that, it's not a trademark yet. So they can't register it because it's not a trademark yet. So yeah, that's exactly what that means. I have a crazy question. How do celebrities get their name trademarked, and what categories would it go in? That's not that crazy, actually. That's pretty reasonable, good question, actually. How do they do it? The same way any of us do it. They apply with the USPTO and go through the registration process. What categories would it go in? It depends on what they're using the trademark with. Celebrities, they do often personal appearances, or a lot of them sell merchandise, sell goods. They license their name to be used with the sale of other products or services. Let's look at my favorite celebrity, of course, Britney Spears. I know for a fact she has a number of trademarks registered for a lot of different goods and services. And I mean, not only does she, through her company, which I think is a funny name, what is it, Baby One More Mark LLC, it appears to be the entity that Britney uses to hold all of her intellectual property, or her trademarks at least, Baby One More Mark. Hats off to you, girl. That's why I love her. Anyway, not only does she have a handful of trademark registrations, but a lot of those are her name specifically, Britney Spears. Let's see, she has Britney Spears registered in Class 3 for cosmetics, fragrance products, perfume, body care, skincare, moisturizers. So she sells cosmetics products with her name as the brand. So that's the class that she used for that registration. She has one for hair ornaments and hair accessories, jewelry, backpacks, photo plaques. So again, she's using her name, Britney Spears, on these products or in connection with the sale of jewelry and these other products. Something that's maybe a little more, I guess, to your question, is this other registration she has for phonograph records featuring music, pre-recorded audio cassettes and compact discs featuring music, pre-recorded videotapes, entertainment services in the nature of live performances by a musical artist. So a lot of musicians and musical artists will register their name, their stage name, maybe their band or their group name in connection with live performances by a musical group or a musical artist. And then they're also putting out, music on CDs and cassette tapes. People still do that probably, but that's also being used in connection with those products. Let's check maybe someone who's not just a musician. How about good old Kim Kardashian? Of course, she's going to have a bunch of trademark registrations as well. She has one entertainment services, live televised and movie appearances by a professional entertainer, entertainment services, namely conducting parties, personal appearances by a media celebrity. So she uses her name in connection with making personal appearances and conducting parties. And so that's one of the classes that she's registered under. Advertising services, namely promoting the brands, goods, and services of others. Endorsement services, promoting the goods and services of others. So again, she lends her name, she licenses it basically to other companies and they use it to endorse. She endorses those products. So that's a different class. And then a logo, a design mark for fragrances. So apparently she has a perfume as well. So, it depends on what they're using their name for and the goods and services that they're offering or putting out there using their name. So it depends. There's no one way to answer your question, but there's a million ways to answer it. And that's why trademarks are so fun. Okay, that's all this time. If you learned a thing or two, hit that like button, subscribe to my channel so I can stay all up in your business. If you want to have some more fun and go through more comments with me, I've got another video where we go through all your comments and questions here. You can check it out and I will meet you over there. Thanks so much for watching. I'm Aiden Durham and I'll see you next time.